All right, let's call this meeting to order. Thank you. If we can all stand for the pledge and then remain standing for the invocation.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now we can all bow our heads for our prayer. We thank you, Father, for us being here on tonight. We ask that you look over our city, look over the country, look over our family and friends all together. Let our leaders make the right decisions on tonight. What's best for our community, our city, and overall, in Jesus' name, amen.
Thank you. Mr. Angelo, can you call the roll?
Ms. McCollum, Ms. Wilson,
Here.
Ms. Douglas,
Here.
Ms. Johnson,
Here.
Mr. Galucci,
Here.
and Mr. Leidick.
Here.
Okay. All right, if everybody's had time to go over the minutes that were distributed electronically, we need, if anybody has any changes or, no?
Nope.
No? Nobody? Do we have a motion to approve?
Move to approve.
Second.
That was the minutes from 10:14.
Call for hand vote.
Can we get a hand vote on that, please?
Aye.
Okay.
Minutes are approved.
So the minutes are approved. We have before us two matters that must be considered and voted on by Planning and Zoning Board in a quasi-judicial manner. The two items are Z 2503, being an application submitted by Carol Chadwick, P.E., as agent for Florida First Coast Investment Corp., Inc., a Florida corporation, to amend the official zoning atlas of the land development regulations by changing the zoning district from residential single-family 3, or RSF 3, to commercial neighborhood, CN, on property located on parcel 02703-014. The second one is SPR 2511, being a petition for site plan review accompanied by resolution number 2025PZ SP11, approving an application by Michael Hicks as agent for Terps Acquisitions LLC, a Florida limited liability company, for approval of a site plan for a new construction restaurant cookout in a commercial intensive zoning district and located on parcel number 02579-01, which is regulated by the Land Development Regulations, Section 4.13. I'm now going to ask the city attorney to run through the procedures to be used in these hearings and to inquire the members of the Planning and Zoning Board regarding any ex parte communications.
Thank you, Chair Douglas. The purpose of the following procedure is to ensure an applicant provides a complete presentation of the request of the Planning and Zoning Board prior to any testimony being provided by staff, so the applicant receives a full and fair hearing on their application, and any decision by the board is based on evidence presented. All public testimony will be taken under oath, and everyone testifying will be subject to cross-examination. All documents and exhibits will be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to evidence of record. To accomplish this, the city, the applicant, the Planning and Zoning Board, and other interested parties will be recognized in the following order. First, we'll hear from the city, then the applicant, and then any party interveners, followed by public comment, and then cross-examination by the parties and any interveners. After that, we'll proceed with any additional response if the chair allows. Then we'll move to questions from the board, followed by final arguments from the parties and any interveners. I'll then advise the board as to law and necessary findings, and the board can deliberate and vote. All persons have the right through the chairman to ask questions of staff, other speakers, or to seek clarification of comments made by staff or other speakers and respond to comments or questions. All people presenting written materials to the board must ensure a copy of those materials is presented to the clerk for the board for inclusion in the board's record of proceedings and official minutes. While the Planning and Zoning Board welcomes comments from all persons with an interest in the proceeding, Florida law requires the board's decision and quasi-judicial actions be supported by competent, substantial evidence presented to the board during the hearing on the application. Competent, substantial evidence is evidence a reasonable mind would accept as adequate to support a conclusion. There must be a factual basis on the record to support opinion testimony from both expert and non-expert witnesses. People presenting testimony may support their testimony by relying on factual information provided by city staff, the applicant, or other information included in the city staff report. At this time, I need to inquire of each of the members individually if they've received any ex parte communications involving any of these matters, and if so, to please disclose them. Starting at the end of the dais, Mr. Carlucci?
No.
Ms. Johnson?
No.
Ms. Wilson?
No.
Mr. Leidick?
No.
And Chair Douglas?
No.
Okay, thank you. At this time, if each person who's going to offer testimony or speak to these two applications, if you could stand and raise your right hand to take an oath. Do each of you swear to tell the truth, the whole truth, and nothing but the truth in tonight's proceedings? Yes. All right, thank you. The first matter before you is proposed application Z2503. This is a continuation of a hearing that was commenced on May 13th, 2025. The resolution is a resolution of the Planning and Zoning Board of the City of Lake City, Florida, serving also as a local planning agency of the City of Lake City, Florida, relating to the rezoning of less than 10 contiguous acres of land pursuant to an application by Carol Chadwick as agent for Florida First Coast Investment Corp., Inc., a Florida corporation, the property owner of said acreage, recommending to the City Council of the City of Lake City, Florida, approval of an application to amend the official zoning atlas of the City of Lake City Land Development Regulations by changing the zoning district from residential single-family 3 to commercial neighborhood of certain lands within the corporate limits of the City of Lake City, Florida, repealing all resolutions in conflict and providing an effective date. I'll turn it back over to you now, Ms. Douglas.
Mr. Angelo, you have introduction, summary, and staff analysis, application Z2503.
Yes, ma'am. So this is Z25-03. This is a rezoning for Buddy's Lake, and then what we're doing is rezoning the two parcels you see there, 12516-000 and 125-14-000 from residential single-family 3 to commercial neighborhood. And just to kind of give a brief recap, because we have heard this one, so I'm really just kind of pull the map back up, kind of, go back over kind of where we were and kind of what we've kind of want to present to you tonight. So you've got the parcels here, is this one right here, and then you've got one right here. And you have a commercial neighborhood district right here already that does border Baya. So we've done a lot of research on whether we should do a text amendment. It might up being a lot more complex than what we thought we would do, because you also need to amend the comp plan. And because of the Senate Bill 180, any comp plans that we send to the state would probably be rejected, and that because of Senate Bill 180, because they're not allowing any kind of text amendments to the comp plan right now, and that because of Senate Bill, just the way it's organized and all. We might be able to get it to go through because it does kind of, we're opening up stuff, but if they see it as restrictive at all, then they would reject it back, and then we're back to square one, and then the zoning wouldn't match the future land use. So what we've come up with the applicant, kind of working with them, is they're going to, let me get back to the map again. So they're going to combine all these 5 parcels into one parcel, and that way it's one parcel located on Baya. So it'll all still be on arterial. That way we can still protect the integrity of other neighborhoods and keep from having a commercial neighborhood in the middle of a residential subdivision. So we felt like this would be at the best interest of both the applicant and the protecting the regulations as we need. As you can see, this is a picture of the street here, just to kind of give a brief recap of what you had there, and that these are the buildings right over here that would be rezoned. And so at this point, the staff recommends granting a conditional approval. As part of this approval, the parcels must be consolidated under a single ownership and combined into one tax parcel, which will be located on Bay Avenue. All right, that's it.
Thank you.
And I would like to move my application record also.
And the presentation as well?
Yes.
Okay.
Okay, Ms. Chadwick, do you have a presentation?
No, I would just like to thank Mr. Angelo for coming up with a great solution to the problem. Hold on to him. And
Thank you.
seeing if you had any questions for me. And I need to move my application into the record, please.
Thank you. Do we have any party interveners present? No? Okay. Any public comment? No? Group representatives? Any cross-examination from either of the party, from the city or Ms. Chadwick? No? Okay. Okay, any questions from the board?
I've got a question. After they combine the 5 parcels into one, will there be access to the whole parcel from Baya, or will people still need to go on the residential street to enter whatever's going on in the back?
I am going to work with Mr. Slay on a site plan showing that there is indeed enough parking as we go through all the buildings, see what's in them, and there is access to all of the buildings off of Baya, but it will still have access to the street behind.
Let's see, I had one other. I think that's it for now.
I'm sorry?
That's it. I'm good.
Okay.
Yep.
Anybody else have questions?
I have one,
Oh.
Madam Chair.
Mr. Leidig?
For Mr. Angelo, you'd indicated that with what's moving through the Senate right now, chances are good that this would be seen as being more restrictive by adding additional residential streets that are not on primary arterials into the zoning for a CN commercial neighborhood. How would that be seen as being more restrictive? It would actually be loosening up some restrictions.
In my impression, it would be loosening up the restrictions, but just the way the state is viewing everything, we didn't want to take the chance of going through that whole process and then getting it kicked back to us at the very end. And because there's been so many jurisdictions that have had things kicked back for, that they've worked on for years, or just immediately. We've got even a text amendment that we want to do with the comp plan on mixed use that we're going to have to hold until we see, what the state's going to do with Senate Bill 180.
So in essence, is this the end of home rule for local communities such as ourselves, and the state's pretty much going to take over planning and zoning for us?
I don't think so. I think, this legislature session, we'll probably see a lot of changes to that. And I think some of it will be pulled back, or we'll get a lot of clarity on what the bill is supposed to be.
Okay, do we anticipate, and this may not relate to this petition exactly, but do we expect a lot more of these creative out-of-the-box solutions to some of our problems moving forward?
I mean, if it makes sense and it's in the best interest of the community, if we can work with the applicant and do what's right by the community at the same time, that's kind of where we want to be.
Okay, that's all I have, Madam Chair.
Okay, thank you. Nobody else? Okay, do we have any final arguments from either Ms. Chadwick or from the city? No? No? Okay. Mr. Martin?
Thank you, Madam Chair. The decision of the board should be based only on evidence presented by sworn witnesses. In addition, the board may make its recommendation to the city council after taking into consideration those matters listed in section 15.2.2 of the city's land development regulations. At this time, the board may discuss the application, testimony, and any findings of fact upon which the board wishes to base any decision, and vote on your recommendation to the city council concerning application Z 2503 following an appropriate motion and second. And if it is the intent of the person who proffers a motion to incorporate into their motion, and Mr. Adler, if you could return back to the prior screen with the conditional language in it. In the PowerPoint, yes. If the person proffering the motion intends to incorporate that condition, if you could just read the condition off the screen into the record, and then we will prepare a resolution to that effect. But I don't think it will need to come back for a vote on the resolution, as we have to do sometimes, since you're reading it verbatim into the record.
Okay.
So.
That's the one? Okay.
Yes.
Okay, thank you. Do we have any discussion amongst the board members?
Not really, other than, looks like we're gonna be doing some creative work up here to get around Tallahassee for the next couple months.
Evidently. When are they supposed to vote on that? Senate bill?
It could be sometime later May, June, before we really know what the state's gonna do.
Okay. Okay, thank you. Nobody else? Okay, do we want to vote, or do we have a motion, rather?
Move to approve Z 2503
Second.
conditionally.
Second motion.
Want to
Do I need to read the whole
read
thing
the
right now?
conditions,
Yes,
please?
if you could
Yes.
read that condition into the record.
Move to approve if granting conditional approval. As part of this approval, the parcels must be consolidated under a single ownership and combined into one tax parcel, which will be located on Baya Avenue, a designated collector road.
Thank you.
Second that motion.
Okay, all right.
Roll call vote.
Roll call. Mr. Angelo, roll call vote?
Yes. Ms. Wilson?
Yes.
Ms. Douglas?
Yes.
Ms. Johnson?
Yes.
Mr. Carlucci?
Yes.
And Mr. Leidick?
Yes.
No? Okay, congratulations. Thank you. Conditionally.
Would you like me to proceed with the next one, Madam
Yes,
Chair?
please.
Okay. Board members, you now have before you proposed resolution 2025 PZ SPR 2511, which states a resolution of the Planning and Zoning Board of the City of Lake City, Florida, approving an application of Terps Acquisitions LLC, a Florida limited liability company, submitted by its agent Michael Hicks for approval of a site plan for a proposed restaurant within the corporate limits of the City of Lake City, Florida, identifying said lands by the 2025 Columbia County Tax Parcel Identification Number 353S16-02579-001, repealing all resolutions in conflict and providing an effective date. Madam Chair, turn it
Thank
back
you.
over to you.
Mr. Angelo, presentation, city staff analysis?
All right. So this is SPR 25-11. So it's a site plan for Cookout, which will be a new proposed restaurant. This is for parcel number 02579-001, which has a future land use of commercial and a zoning district of commercial intensive. The applicant is seeking to get approval of a site plan for the new Cookout restaurant. And they do, right now they have one ingress egress, which is on Highway 90. And so one of the things that we had to work with the applicant on, because DOT was pushing back on that entrance. And so one of the recommendations we're going to do at the end, I'll kind of go over the recommendation, what staff recommends. But DOT wanted them to close that entrance and use the movie theater entrance, and which will not work because they do not have easement through there. And so they're working with DOT on that. DOT has, said as long as there's no way to move forward, or get to the site other than that entrance, then they'll work with them on that. So, but we'll go over that a little bit more on the site plan. I'll show it to you.
Okay.
So this is the current proposed site plan. So because of that, this is the entrance that they were going to use on Highway 90. This is one that would go into where the movie theater that they would like to keep, but because of they don't have the access from the movie theater, they would not be able to use this one. So they're going to close this off. And I've got a new site plan that I'm going to introduce tonight as an exhibit, and that'll show that. So I'm gonna go ahead and approach the board and present these to you.
Thank you.
All right, so I'd like to introduce this as Exhibit A. And this is, you can see on the bottom of it, they've closed off that access. And, so it is a minor change to the site plan here. And there are a couple of minor tweaks also in there that they'll do. And this is the proposed site. This is the access where they wanted them to use and coming in through here. And then that way they could close this off because it's so close to this one. And then you can see it on the aerial here also.
Where's the movie theater? I want to get
The
it.
movie theater is right back here. Or sorry, right here.
'Cause I
This
wanna
is the
get-
movie theater here. This is the where cookout will be. It'll be right here. And then the movie theater has an entrance that goes in through right here. And this is the one for that will be used for them. And then you got Planet Fitness right back here. All right. So the staff review, customer service notes is the standard notes. They'll need an application. Sunny River Water Management had a pre-application meeting with them on August 5th, and it was determined that the site was not grandfathered in, therefore an ERP 10.2 self-certification will be needed for the site, which is standard on when you're putting down new pervious pavement down. So this time the staff recommends to do a conditional approval of SPR 2511 based on the condition of DOT approving the entrance on Highway 90. So as long as they go through the permitting process, which they're going to have to do anyways with DOT, and then they get that permit approved, then we'll be okay with moving forward with the site because then they'll have access off of Highway 90. And that's it. And I would like to move my report and application and the presentation into record.
Thank you, Mr.
Thank you.
McMillan. All right. Do we have a representative for the applicant?
Hey, good evening. Michael Hicks, and I'm with a firm, Sambatech. We represent, we're Cookout's engineer of record, and we also are the agent for the current owner, that is Terps Acquisitions, and Cookout has an option to purchase the property. And we appreciate working with staff on this, and also we definitely are in support of the condition of the approval as written here into the record for staff recommendation. So I'm available for any questions if you may have about who Cookout is or anything site plan related. I'd be glad to enlighten you further. Thank you.
Okay, thank you.
Thank you.
We'll get back to you.
All right.
Do we have any party interveners present? Any members of the public that want to comment? No? Okay. Any cross-examination from the city, or do you have questions for the city? No. Okay. Does the board, any of the board members have questions for either the city or the applicant?
I have one, Madam Chair.
Go ahead, Mr. Leidig.
Mr. Angelo, the attachment that was posted to the city's website with the staff review, all the fields in that were blank. Were there any other substantive comments from any of the other city departments?
No, everything else was pretty straightforward. There is a lot of utilities around that. So anytime any utility work or any demolition, anything like that is being done, the utility department will have to be notified because there's so much utilities around the perimeter of that lot.
Okay. At the time this ended up getting posted, was that just a clerical mistake that the review was blank in all the boxes?
Yes.
Okay. That's all I have, Madam Chair.
I got a question for Mr. Hicks about the site plan. Do you guys plan on using the building that's already there, or are you going to tear it down and start
No,
over?
the building would be torn down,
Okay.
and new Cookout will be approximately 1,660 square feet.
What's going to happen to the people that are currently in the building? They're just going to.
I'm not aware of any
There was
existing.
an urgent care place that was there for a while. Is that not there anymore?
I don't believe it's there any longer,
All right.
to the best of my knowledge.
That's all I had.
Thank you.
Was that Daniel Krapp's old
It
real
what used to
estate
be
office?
Craft's Agency, and then they had an urgent care in there for a while.
Now, is the restaurant just a park, or is there a drive-through
Yeah, yes, ma'am.
that's going to affect the traffic?
It's a drive-through only restaurant. I don't know if you're familiar with the brand, but more than half of the restaurants that they have are drive-through only restaurants.
Tell me more about it.
Okay, sure. You like milkshakes? There's 40 different kinds. There's anything you get from the menu that you can imagine. There's from barbecue to there's no seafood though, but everything else you can imagine is on the menu. The family, it's still a family-run company based in Thomasville, North Carolina. There's 350 approximate locations in the Southeast. And if I'm not mistaken, this will be the third location in Florida. Tallahassee just recently opened, and as well Pensacola earlier this year, if I'm not mistaken, or late last year. So,
Thank you.
mhm.
Thank you. Anybody else? No? Okay, thank you.
Thank you.
Do we have any final arguments? Anything else? No? No? Okay. Mr. Martin?
Thank you, Madam Chair. The decision of the board should be based on the evidence presented by sworn witnesses. In addition, the board may make its decision after taking into consideration those matters listed in section 13.11.3 of the city's land development regulations. This time, the board may discuss the application, testimony, and any findings of fact upon which it wishes to base a decision and vote on the proposed resolution.
Thank you, Mr. Martin. Do we have discussion amongst the board members? Do we have, anybody want to make a motion?
Move to approve SPR 25-11 conditionally if DOT approves their entrance on Highway 90.
Second, with condition.
Thank you. Roll call vote. Mr. Angelo?
Yes. Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
or Mr. Carlucci,
Yes.
and Mr. Leidick.
Yes.
No? Yes. Okay, congratulations. Okay. Okay, so next we have LDR 2502, an application by the City Council of Lake City to amend the text in definitions, Article 2, 3, and 13 of the Land Development Regulations, adding provisions for an administrative approval process. Mr. Angelo?
All right, so this is LDR 25-02. This is a text amendment to add an administrative approval process into the LDR. So an administrative approval process is used for like site plans, affordable housing projects, granting the LDR administrator the authority to approve for conditions, or deny an application. So certain, the reason we're doing this, there are certain initiatives that the state has put in, like one is the Live Local Act for affordable housing, which states in there that every city and every county must have some kind of administrative approval process. If somebody goes through the Live Local Act and they actually meet the requirements of the Live Local Act, we have to hear those and approve those administratively, and versus coming in front of the board. And Senate Bill 1730 clarifies the administrative approval process this year by amending paragraph 7E to call out the proposed development under the Live Local Act are to be approved administratively without any action by either the local legislative body or any quasi-judicial reviewing body. Also, you have the YIGBY, which is Yes in God's Backyard. This bill allows religious organizations to build affordable housing on their property or the property that is contiguous to their property, and these developments are to be reviewed and approved administratively also. Then you also have the site plans. And so why is this important to Lake City? And numerous jurisdictions have an administrative approval process. for site plans. For example, Columbia County has had one in for at least 10 years or more, and that they've had an administrative approval process currently for minor site plans. Jurisdictions with the administrative approval process, you have the Columbia County, which is about 10,000 square feet or less of building, and anything beyond that then would still come in front of the board. And Live Oak is at 20,000 square feet or less of building space. That was a recent change to their LDR about 5 or 6 years ago that they added to that. So anything that's under 20,000 would be approved administratively. Anything over that would come in front of the board. And at Ocala and Gainesville, anything in the commercial and industrial is approved administratively. Gainesville, everything I was researching, I think everything they do now, site plan wise, is all done administratively. Nothing comes in front of the board as a quasi judicial matter. And so some of the benefits to that, it allows for an expedited process. No public hearing is required, therefore no advertising timelines, which also reduces cost and reduces administrative burden on and increased staff efficiency. And I do have, you got the current text that you have in front of you tonight, which is ours, we were proposing originally was 7,500 square feet or less. But from reviewing Columbia County's, Live Oaks, and some of these other jurisdictions, we've got two other ones that we'd like to introduce to you tonight as Exhibit A and B. And that way you can look over those and we can kind of discuss them and kind of see which way the board would like to go. And our thought process in this is, twofold. One, let's speed some of the processes up for the applicant to get some of the smaller projects through and not burden somebody that's building a small office space and with a lengthy site plan approval process. We'll still go through the same review that we do currently right now. Everything will still come into the city, all the city staff will still review them, and that process will not change. And the only thing that would change is which way they get approved, whether they come in front of the board as a quasi-judicial or whether the LDR administrator would have the authority to approve them. So that would help speed up some of the smaller projects. And a lot of these are already permitted uses in that. And if they check all the boxes of the land development regulations, we really don't have a justification to deny them. And so then as long as they meet all the requirements of LDR, then the LDR administrator would have the authority to approve it. And I'll go ahead and pass out the two different ones for you and give you a couple minutes. And I'll kind of explain the two different options here.
Thank you. Oh my goodness.
All right, so while you're looking over those, so I'll kind of explain where the changes are, and because everything else is pretty much consistent with what you have in your packet. The only difference is section 13.11.5, and where we had 7,500 square feet. One option we proposing to match what Live Oak does, and have 20,000 square feet of additional building, or 40,000 square feet of impervious surface. The other option would be to, if it's a residential development or anything that's not contiguous to a residential development, then we would approve administratively. But if it is contiguous to a residential district, then it would go back to kind of what's in front of you right now, where you have the 7,500 square feet would still be approved. But that way, if you had anything that might be controversial, with a subdivision or something like that, could still come in front of the board and still be heard. So we're not taking that function away. And kind of where we felt would be the better of the three options. So that way we're still protecting the residential districts, but moving things through the process a little bit quicker. And so I'm happy to answer any questions you have on this and get your feedback and see which way y'all would like to go.
Madam Chair.
Mr. Leidig?
Mr. Angelo, I do have one question. Would this also take other boards' roles and responsibilities in the process out of the equation?
No.
For example, things subject to review under Historic Preservation Agency rules, guidelines, and sections?
No, this would strictly only apply to site plan reviews and anything that relates to affordable housing and that meets the Live Local requirements. It would have to meet the state statutes on affordable housing. And if it meets that, then it would go through this process or a site plan that will meet the requirements that we set forth here. But it would not affect your Board of Adjustments, wouldn't affect any kind of rezonings, because those have to be done in a quasi-judicial matter, and wouldn't affect the historic preservation at all.
Okay, so for potential Live Local Act projects taking place within the historic downtown core, there would still be a review process for sufficient compliance with the National Historic Preservation Act and various city historic rules and guidelines.
Yeah, we would still look at them from a historic perspective, and I'd have to look a little closer into the historic preservation. I know there's some language in the Live Local Act that they can demolish buildings and through an expedited process, but I don't know the whole ins and outs of that. But our thought with this is strictly for the site plans and affordable housing initiatives, and not mess with the historic preservation. We would still want to go through that same process.
Expedited demolition of historic structures?
Well, that's what's in some of the state statutes under the Live Local. And
does that also occur administratively without it coming before the HPA?
I don't know enough about Live Local Act as far as the historic nature of it. I'd have to look a little bit more into it. But I can definitely do a little research and bring it to the board and do a workshop for the historic reservation. And that way we can kind of see what that looks like and give you a little bit more information on that.
Understood. That's all I had.
Thank you. Any other questions for Mr. Angelo from the board? No? Thank you.
All right, thank you.
Any discussion amongst the board members?
Yes. So I think we should definitely go with the one that has the residential requirement, because a lot of times, if you're not around residential, there might not be a lot of people mad about it and want to say something. But if it's around residential neighborhoods, I think people should have the option to come here and say what they need to say or want to say. So I think we should go with that option.
Okay, thank you. Anybody else? Mr. Leidig?
I would tend to agree with Mr. Carlucci. Additionally, on option B, the proposed language for 13.11.5, 20,000 square feet for a new structure, 40,000 square feet worth of additional impervious surface. That is awful large to be administratively approved with no public comment whatsoever.
Agreed.
Agreed.
I actually was thinking perhaps we should table this until Mr. Angelo can do the research on the historic effects. Any thoughts on that?
I agree.
Mr. Leidig?
Yeah, I'd kind of like some more information about what this is going to look like in terms of this board's future moving forward. So yeah, if we can get a little additional information on how this is going to play in with other aspects and functions of what our three boards do, that would help me out quite a bit.
Anything else? Yes, Mr. Angelo?
So if that's what the board would like to do, is table it to to the next meeting to do a little research on the historic. If you can kind of narrow down which one of the three that you would want to go for, then what I'll do is bring that back as the one that we'll actually present and recommend, and then we'll do the information on the historic also.
Okay. do we need to vote on that or just a general agreement?
I think you can give a general consensus of the board that that's what you want. One thing I would offer is, given some of the legal issues involved, it may actually be the February meeting before we're able to get it all pulled together and able to pull together for a workshop for the board. But
Okay,
Okay.
okay.
And this text amendment change, is this also contingent upon any pending legislation in the legislature in Tallahassee?
I'm not aware of any legislation right now that would affect it, but that doesn't mean anything until after the legislative session's over with, so.
But like, for example, earlier when we were talking about the one Senate bill that hasn't passed yet, those issues are contingent on that. This text amendment, do we know if it is in fact contingent on something that is slated to be heard this session?
We don't know.
Okay.
Even with the Senate Bill 180 glitch legislation, there's always the possibility that doesn't pass, and we don't know exactly what elements of it they're going to try to tweak. And so, you just don't know. We just know they're going to take a look at it. They may make changes to it. We don't know what the changes are, and we don't know how it's going to pass out of the legislature and be signed, if it does at all. So you got to deal with what you got in front of you right now, and that's all you're guaranteed.
All right, Madam Chair, and in that case, I'd recommend we go with the version of 13.11.5 that parses it out into Part A dealing with residential, Part B dealing with commercial or mixed-use zoning, and with the numbers of 7,500 square feet and 20,000 square feet of impervious.
Okay.
Agreed.
Thank you. Mr. Angelo?
So, something with Richard, one thing that we, could do if we wanted to vote on it tonight is do a conditional approval, and which one you want to do as part of the condition, but also put a restriction. We'll come back, when it goes to the city council, we'll actually go to the city council with a restriction of anything in the historic district. So anything in the historic district would still fall under the normal guidelines. And that way it protects the historic district.
So I'm going to recommend that you wait until a workshop on all of this, so you're fully
Okay.
informed.
Okay. Yeah, I like the idea of tabling it. I think definitely that 7,500 and 20,000 square foot option would be the one. 20,000, 40,000 is a large project. Anybody else? Thoughts?
No, I'm
Same.
with you.
Okay.
Yep.
Okay. That's what we want to do then. We'll table this until we can
Until
get
February.
a little more clarity, and definitely the 7,500, 20,000.
So the first option that was in the packet,
The 75?
or the one that with the
The one with the
that protects the
residential.
One that you
residential.
Yeah, the
handed
one with the
us.
residential.
Okay, that's what I want to make sure I clarified.
Yes. Okay. Next is LDR 25-03. An application by the City Council of Lake City to amend the text of the LDR to add provisions for a new zoning district, mixed-use zoning district. Mr. Angelo?
All right, so I'm gonna go through the presentation pretty quick because you've already seen this presentation on the mixed use when we did the workshop, and it's also been in front of the city council. So we pretty much everybody knows what the mixed use zoning is. It's just combining the uses in one area versus Euclidean zoning, which you've got strictly commercial or strictly residential component to it. This combines those uses together. And so you've got a vertical mixed use, which is what you will see like at Celebration Point or like across the street here with the Blanche, where you got the retail below and then the residential component above. And then you've got a horizontal mixed use, which you'll have like usually commercial to the front, and then you'll have like a subdivision to the rear of that, and all working together and making the area more walkable, bikeable. And some of the benefits to the community is an economic growth, infrastructure savings, increased property values, community spaces, and land utilization. Infrastructure savings, because you're combining your uses in one area, and you're putting you can bring utilities to a larger group of commercial uses and residential uses and not have to have as many miles of infrastructure in the ground, whether it's roads or utilities. Economic benefit is, you do provide, like the Blanchard across here, help support local businesses. So when you have that residential component mixed with the commercial, you automatically are adding a benefit to those commercial businesses by putting tenants and stuff that will shop those locations. And, from a safety standpoint, studies have shown between the mixed-use developments, that there's a lot of traffic safety that goes into them because these communities are a lot more walkable and bikeable and you don't have to have cars to drive to a commercial development from the residential subdivision. So you wind up having a lot more safety issues with a utility and zoning. Community spaces, community developments with an open community open space tend to create a social benefit for the community by allowing people to gather and enjoy the time spending time together. Spaces like parks, playgrounds, walking and biking trails, food truck courts, stages with a seating area, etc. These will help connect a community. Your property values tend to go up on mixed-use developments also, and the combination of the uses and the development help create a desirable and convenient living environment, potentially boosting the property values. Land utilization, horizontal mixed-use developments help create a community within a community, and vertical developments tend to take up less land by allowing residential dwellings to be above commercial developments. And then for transportation-wise, usually you'll see like e-bikes, microtransit, golf carts, shared paths, different things like this, making them more walkable and bikeable. A lot of mixed-use developments also, you'll see curbless shared streets, making it more walkable and more enjoyable, and more pedestrian-focused. This is an example that we found where you've got the commercial down here below, and then you've got the residential up above. And here's another one where you've got retail, entertainment, residential, and office all in the same building. So some key text that you'll see in the text amendment. One of the things we're recommending is to do a density of 40 dwelling units per acre, and then also have a minimum single-family lot size of 3,600 square feet, and then having a minimum non-residential lot size of 7,200 square feet. That would be our non-single family, so anything that would be a multifamily would need at least 7,200 square feet or more, and then having an alcoholic beverage establishment permitted within zoning MU1 and MU2, and then truck and bus maintenance facilities permitted in MU2. MU2 would be more of an industrial and residential mix of uses, and that's why you'll see the truck and bus would be okay with that, because the people that are tending to move into that area already know these uses are there and wouldn't be necessarily against it, because that's somewhere they could walk to work or something like that. Key takeaways, we kind of went through a lot of these already. The benefit of a mixed use is the walkable, bikeable, and that type of environment. And that benefit to a city is increased tax revenue because you usually get multiple uses in one area. The benefit to the citizens is a more enjoyable environment where a lot of uses are together and they don't have to necessarily travel to get to the where they want to go. And any questions?
Mr. Leidig?
The establishment of the multi-use zoning categories, both 1 and 2, that's going to be complementary to and in addition to the mixed-use category we already have, which would be commercial CBD, correct? This is just bringing that out of the city core into the rest of city limits?
Correct. And right now it's called compound use, which is allowed in the central business districts. We already have a mixed use, which is how the Blanche was able to do what they did. And even in residential office, you could potentially have a little bit of office space and a little bit of residential mixed in there. This is just actually gearing or focusing on actual zoning district where somebody could come in and do a larger scale mixed use and actually rezone it and do a nice, subdivision or a nice development, kind of like what you see at Celebration Point, or something like that, where it's a lot more enjoyable. And that's kind of the focus of the MU1 and MU2. And so what we did was we looked at a lot of jurisdictions that had mixed use and kind of pulled from a little bit from each one and kind of created what we have now.
Okay, so this is just adding additional MU categories without making any changes whatsoever to current existing CBD style of mixed use?
Correct. Yep. This would be a completely new zoning district in the LDR. And it'd just be another zoning district inside the LDR. And there is a comp plan amendment that eventually we'll want to go back and do, because right now you've got to have 50% of it has to be commercial. And then you can have 45%, I think, can be residential, and then 5% open space. And we want to change those mixes, but because of the Senate Bill 180, we're going to wait, till probably June or July or so to introduce that. And so right now we'll just kind of go as it is. We already have the mixed use in the comp plan. That's why we need to really adopt some mixed use zoning district into the LDR.
Okay. And then my second question, looking through the non-residential principal uses within these categories, can you explain to me the rationale for why alcohol beverage establishment would be permissible? Let's see, where's the legend? Permitted by right for an MU1, whereas a microbrewery requires a special exception.
So a microbrewery is a little more intense, and typically they've got a lot of equipment that would be going there. So we'd want to look at those a little closer, where an alcoholic beverage establishment, like a bar or something like that, you wouldn't necessarily have that equipment. And so we need to take a closer look, how much water are they consuming, stuff like that. So that's why the rationale. And plus, a lot of the jurisdictions that we looked at had them kind of set up that way, and the same way.
All right, that's all I have, Madam Chair.
Okay, thank you.
I had a question, Madam Chair.
Carlucci.
I'm assuming I could check, but my iPad decided it absolutely has to restart right or update right now. So I'm assuming it's just commercial and residential. Like, you can't just throw some industrial and residential mixed together, right?
So in MU2, that district would be industrial and residential. And MU1 is focused more on commercial and residential. So there's two separate zoning districts within the mixed use.
So how's that look with industrial and residential in the same building?
A lot of it, because usually when you see industrial, like in MU2, it'll be more of a horizontal mixed use, where you may have like warehouses and stuff to the front and like a subdivision to the rear, and something more along that lines. And you wouldn't really see it in a actual vertical structure.
Okay.
And this would be mostly light industry. We're not talking
Yes.
tire factories right next to apartments.
Right.
Okay. That's what I was worried about. Yeah.
Right,
I heard
yeah.
what you were getting at.
Yeah.
Yeah.
Any other questions? No? Okay, thank you.
I think.
Discussion?
Yeah.
Any discussion amongst the board members?
I'm good.
I like it.
I like it. Yep.
Yeah. Okay. Do we have a motion?
Oh, I can't. My iPad's not.
Oh,
I don't know what the number is.
Madam Chair, I move approval and recommendation of the City Council that we adopt the text amendment as presented in petition LDR 25-03, dealing with the mixed-use zoning district.
Second.
all right. Roll call?
Madam Chair, just for clarification, that would be to adopt resolution PZLPA LDR 2503.
Yes.
Yes.
Okay, all right.
All right, so Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
Mr. Galucci,
Yes.
and Mr. Leidig.
Yes.
All right. Okay, next, we have LDR 2504. An application by the City Council of Lake City to amend the text in sections 4.9, 4.10, 4.12, 4.13, 4.14, 4.15, 4.16, and 4.17 of the LDR, amending the building height and lot sizes. Mr. Angelo?
All right. So the current building height right now in residential commercial districts is 35 feet. This was adopted in 2008. So in the LDR, originally you had a building height set in 2006, and that, which was basically went by the Florida Building Code. And so whatever the Florida Building Code would allow, which was kind of unlimited, and depending on how the building is built. And in 2008, they came back and they brought it back down to 35 feet for some reason. This was never put into our regulations, and it never got put into the LDR. You know, so they adopted the ordinance, but never got codified into the LDR. So fast forward to where we are today, you've had a lot of hotels built, other structures built that are way over the 35-foot height, and so we have a lot of non-conforming buildings because of that. And so that's the reason we're doing this. We work with the fire department and the building department to find a safe height that we felt like that we could build to and still be, you know, within the reach of the fire trucks and stuff that we have right now. And so we work with the building official and fire chief to set on the basically into a height of 85 feet, and in the RMF1, RO, and Central Business District, we recommend 85 feet unless a development is contiguous to a residential zoning district. If they are contiguous to a residential zoning district, then they would not be able to exceed 35 feet without providing screening or buffering approved by the LDR administrator. And so this is something that we didn't have in 2006 when they originally adopted it. This would help protect some of the residential neighborhoods. And in commercial general, CI and commercial highway interchange and industrial light and industrial, we're recommending to go to 85 feet. And why is this important to Lake City? As we talked about a little while ago, there's numerous buildings that exceed the current height of 35 feet, and we want to update our LDR to be consistent with with other jurisdictions, and to try to make as many of our structures conforming as we possibly can. And so Columbia County has a max building height of 70 feet. Gainesville has special districts which they allow up to 14 stories, and 8 stories in all districts and other non-residential areas. And St. Augustine has a 60 feet. The staff's recommendation would be to approve LDR 25-04. Any questions?
I have one, Madam Chair.
Mr. Leidig?
Just out of curiosity, what's the height of the building we're sitting in right now?
It's 4 stories, so you're probably looking close to 50 foot, between 45 to 50 feet.
So why would we be limiting structures within the CBD to 35 feet if they other residential districts?
So that would be only if they're directly to, that's a change that we're doing right now. So like this building is not contiguous to a residential district, so it would not be, you know, part of that 35 foot. So what we're thinking of is like if you got a subdivision like the Plantation or something, and somebody's building a commercial development right next to it, and instead of having a 85-foot high hotel right next to it and be able to see all through the subdivision, you know, we would want to provide some kind of screening material and otherwise stay at 35 foot as a buffer,
Okay.
just to help protect the subdivisions.
How tall is the tallest building in the city right now?
So what I can understand is Target would probably be the tallest, and I think it's a little over 70 feet. And so it'd still be within that 85 feet.
And the hotels that they just built on city property, or is it all county?
All the hotels that they just recently built, the tallest one I found was 5 stories. So you're looking at about 60, 65 feet, somewhere in there.
All right.
So where did we come up with 85 feet? I mean, that seems kind of tall.
So that is wanted to cover a lot of the buildings we have. Plus, it will go hand in hand with our mixed use in that category, and which is 85 feet or 7 story. There we have 7 stories, which 7 stories would equate out to about 85 feet, and roughly a little less than 85 feet. But if they put any kind of architecture up on the top, then they may get closer to the 85. And this is where we feel that we can safely work with the fire truck. Fire truck has a reach of 100 foot, but they feel like they can safely work at the 85-foot height.
Okay, thank you. Anybody else? Thank you, Mr.
All
Angelo.
right, thank you.
Any discussion amongst the board members?
I think it's a good height if the fire truck can reach 100 feet. I say 85 is fine.
Right.
Yeah.
Mr. Leidig, anything?
No, I'm good.
Okay, all right. Do we have a motion?
Move to approve LDR 25-04.
Second.
All right. Roll call, Mr. Angelo?
Madam Chair,
Oh.
again,
Need to read
and
the
this is a
resolution.
Sorry.
nuance, but it matters because you're actually moving to approve the resolution, which recites a lot of background and factual basis for what the board is doing, rather than just merely approving the application. You're approving the resolution. So the motion would be to approve resolution PZ LPA LDR 2504.
Yeah, what he said.
That. So.
Thank you. All right. Roll call?
All right, Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
Mr. Galucci,
Yes.
and Mr. Leidig.
Yes.
All right. Okay. So with no other new business, rather, move on to the workshop item, which is apparently a discussion and possible action. Discussion on changing the meeting time from 5:30 to 6 p.m. Anybody have thoughts?
I like the earlier time because when I get out, I can eat dinner time. But if moving it to 6 is going to make it so everyone is here on time every time, then I'm fine with it. So if it helps people that, I don't know, live far away or have a lot to travel, whatever, then I'm good with it.
Do you have any thoughts? I know, you work, don't you work a little further away?
I did. I did.
Oh, you do?
I did.
You don't now?
Don't now.
Okay,
In town now.
okay.
So, but I also want to go with the time that's gonna, work for everyone else as well. I've adjusted my working situation, so I'm
Okay.
here.
Okay. Mr. Angelo?
Also, one of the reasons to the change too, one would allow everybody to get here on time and everything. That was one part of it. But we'd also like to kind of match what the city council does, and that way, the citizens don't have to. Well, the P&Z starts at 5:30 and the city council starts at 6. They don't. They all start at 6, and we think it'd just be cleaner that way. And that's kind of why we were thinking of it too.
Okay.
I had a
Well, in
feeling,
that case, yeah, 6.
I had a feeling that might be the thought process there.
Okay.
Mr. Leidig, anything?
I'm in favor of 6.
6 o'clock,
I'm okay with it.
6 o'clock, all right. Seems like 6 o'clock it is then. Do we
right.
need to vote on that?
That'd probably be a good idea, just for the record.
Okay. Do we need a motion as well? Okay.
Move to approve, changing to 6 o'clock.
Second. Mr. Angelo, roll call?
Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
Mr. Galucci,
Yes.
and Mr. Leidig.
Yes.
Okay.
We're hanging with the big boys now.
And just for clarification, who was the second?
Me.
Was it- okay.
Okay, so does anybody have any other items for a workshop? Nothing? No? Okay, move to adjourn.
Move to adjourn.
Second, all right. All right. Moving on. There's the one. All right. Board of Adjustments meeting. Let's call that one to order. Same Do we need,
Roll call shall remain the same.
roll call will remain the same? Everybody's, did we have minutes from October? I don't have a sheet of paper in front of me, I'm sorry.
I see him.
The 14th, okay, so presuming everyone's had a chance to review the minutes from Board of Adjustment from 10/14. Do we need to move to,
Move to approve minutes.
okay,
Second.
there we go. All right, show of hands.
Sign vote.
Okay, all right, minutes are approved. We have no old business, no new business. Same workshop item, change the meeting time from 5:30 to 6.
Move to change to 6.
Second.
All right, roll call vote, Mr. Angelo?
Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
Mr. Calucci,
Yes.
and Mr. Leidick.
Yes.
Okay, we have no other items before the board, so,
Move to adjourn.
Second.
all right. Call to order the Historic Preservation Agency meeting. Roll call will remain the same. We have meeting minutes from 10/14. I presume everybody's had a chance to review. All right,
Move to approve minutes.
Second.
show of hands. All righty. And again, no old business and no new business. And the same workshop item about changing the meeting time to 6 o'clock.
Move to approve 6 o'clock.
Second.
Roll call?
Ms. Wilson,
Yes.
Ms. Douglas,
Yes.
Ms. Johnson,
Yes.
Mr. Calucci,
Yes.
and Mr. Leidick.
Yes.
All righty.
Move to adjourn.
Second.
All right. Meeting closed. Bam.